So we're very happy to have Dennis. He is an attorney who's very well known in our circles. I'm proud to count him as a member of our board of directors. He handles a lot of mortgage foreclosure defense work, well known in the community, sought out as a speaker. He's going to give us some insight into what happens in these condominium situations, and I guess we should be careful. Dennis Borden.
Thank you, Ralph. I appreciate that. One of my usual rants when my Irish gets up is that my expression is, I have a firm grasp on the problem. What I'm trying to find are solutions. So what I'm going to probably do today is I'm going to err on the side of whoever I'm yelling at the time, because I may be posing problems today that we really don't have solutions for, but I'll try and work our way through the situations, and maybe we'll come up with a way in which, especially as far as real estate practitioners are concerned, that we can alleviate some of the stress that we have as far as the pressures on us from a professional liability standpoint. And I've entitled my talk, Be Careful What You Ask For. And I think when we're all kids and we said, oh, I wish I had that, or I wish I was this, our mothers would say, well, be careful what you wish for, because you don't know exactly what that entails. And so the reason for my sort of cutesy title for this presentation is, when we ask for something in a condominium transaction, or the transaction of a purchase or sale of a condominium, we always ask for certain things. And I just want us to think for a few minutes about what we ask for, number one, and number two is that if you get it, what do you do with it? Now, when I've talked about this before, and I've been sort of harping on this subject for the past couple of years, I generally focus on the buyer's attorney as far as what happens when you get the 103-page packet of what we'll call condominium documents, or shortcutting at the 22.1 disclosures. I always focus on, what does the buyer do next? Do you just hand them to your client at the closing and say, here, this was required under the contract and here it is? Or do you have any affirmative duty to do something with what you've received based on not only the requirements under the contract, and we'll be talking basically in terms of the 6.1 contract from the standpoint of what's required. We'll consider that to be sort of generic in Illinois. But also, what's your relationship with your client, and what are they expecting? But this morning, I'm going to take a little bit of a different tact, because during the course of the week, a case was referred to me that I was, at this point, unaware of, although it's a 2004 case. But John Haas sent it to me by email and said, this might be something that you want to raise in your conversation. So I'm going to start, instead of on the back end of the transaction, on the buyer side, I'm going to start a little bit on the front end, because this case from 2004, and I'll give you the site when I'm done talking about the case, so in case you don't want to write down the site, you don't have to. But the case is Mikulecki, Mikulecky, versus Bart, B-A-R-T. Bart was the seller in the transaction. Mikulecki, the plaintiff, was the purchaser in the transaction, but there were other defendants, including the management company for the association, which was, it sounds like it was part of Baird and Warner Management Group. And just to give a real quick, in fact, it's a little bit fact specific if you read the opinion of the court, because one of the things that came out during the course of the case is that the seller had been on the board of directors for a short time. And for some reason, before he put his unit on the market, he resigned from the board of directors. And I think, as they said this morning, some of these cases, when you read the case, you read between the lines as far as, okay, the court thought this, they can't really put it in their opinion, but they sort of got the impression that there might have been some reason why the seller resigned from the board of directors just before he put his condominium on the marketplace. The development had about 200 units in the development, and apparently at some point in time, the board had had a discussion about the fact that there would have to be some fairly significant repairs to the association properties, and that might include repair or replacement of the windows. Obviously, the purchasers, the buyer's counsel, in asking for the typical 22.1 disclosures, expected to get a disclosure as far as any anticipated expenses of the association that were at the time of the disclosure were anticipated. And apparently, under number 3, under 22.1, there was no disclosure of anticipated expenses. The buyer, after the closing, was surprised to find that she got a bill for a special assessment for over $10,000 for window repairs and replacements, which she thought was rather fishy because it occurred too quickly after the closing, and that obviously the association should have expected that there was going to be this expense. The interesting thing in reading the opinion of the court, and in fact, I'll go ahead and give you the site because a lot of us are site hounds. We like this. I'm only going to give you the Northeast 2nd. It's 825 Northeast 2nd, 266, and the decision was in 2004, and rehearing was denied in 2005. But the interesting discussion by the appellate court was that when you named the property management company, who, as I said, was a group of Baird and Warner, you were barking up the wrong tree because clearly under the contract that the disclosures are to be provided by the seller. And so the disclosures that are disclosed by the management company, whoever they are, and we might not be talking about Baird and Warner in the case of a 200-unit building. We may be talking about a self-managed association in a 4-unit building. But the court said that that's real. The 22.1 disclosures are prepared for the seller, not for the buyer, which makes a lot more sense now that I think about it. But we always think that the buyer is the one who is entitled to the 22.1 disclosures and relies on the management company or whoever's functioning as the management company to provide those. And I imagine that the management company breathed a big sigh of relief when they found out that it wasn't their responsibility to provide those to the buyer or the buyer's attorney, or even to the seller to be provided to the buyer, that this was prepared for the seller to provide under the contract. And obviously, because of the facts, I believe that they felt that the defendant, who was the seller of the condo, because of the time that he was on the board and for other reasons, anticipated a significant special assessment and decided he would sell his unit instead and see if he could find someone who would buy it without knowing that there was an anticipated disclosure. Now, that's what you have to read into it, but they did get into the facts as to how long he was on the board, when he resigned in relationship to when he sold his unit, and things like that. So as I said before, generally I start this with, if your buyer's counsel, think about what you're doing when you get the documents. Now I have to shift my focus and say, if you're the seller's attorney and you contact the management company and you pay anywhere north of $400, maybe either $500, even $500 to get a set of documents, the question is that you're receiving those on behalf of your client, the seller, to provide to the buyer. But just the fact that they've passed through your hands or passed through the seller's hands, now what's your responsibility as far as knowing what's in there and you have to do due diligence to decide that what's in that packet is not just what the management company thinks at the time, but what they've been told by the association, who may have in the meantime passed a change in the bylaws that would have affect what's in the package that they haven't informed the management company about. And so the question is, does the seller's attorney have responsibility for what they ask for from the management company? And if you turn to the seller and say, here, I need for you to go through all of this to make sure that it's comprehensive, the seller's going to look at you and go, what are you talking about? You're the attorney. You read contracts all the time, and you're representing me in the sale of this transaction. It's up to you to decide if everything is in there that should be in there, and if not, what are you going to do about it? So the first question I have, the first problem I want to propose is, do we all address what we as attorneys who represent sellers do with the association documents? I can give you one, and I'll give just I'll limit my anecdotal comments, but I was representing the seller of a property that was in an association, and I ordered the full 22.1 disclosures. I got the 78-page set of declarations and bylaws, and I sent them on dutifully to the buyer's attorney. And the buyer said, "What I always do is I look at the plat in the that's attached to the declaration, because I always like to see and verify with my client that that unit that's shown on the plat is the one that they think that they're buying." And I said, "Oh, that's no problem." And I went to it, and there was no plat attached to the declaration. And in fact, actually, curiously, it had been an association that had been around for a while, and there wasn't even one amendment on that. So I contacted my title company and I said, "You didn't order this for me, but I was wondering if you could do this for me. If I give you the information, can you check and see if I didn't get something from the management company that I should have?" And they came back and said, "Oh yeah, when do you want to pick it up?" And it included the complete plat, in addition to several amendments that were not included in the packet that we had paid $500 for, because I did it within a week before the closing, and they got their expedited fee. Of course, it's a PDF file that they could send to you in 3 minutes, but you still have to pay an expedited fee if you do it within, whatever, 5 days, 2 days, whatever. So it started worrying me at the time, and this goes back a number of years ago, but it started worrying me at the time. I rely on the association to tell the management company what has changed in their declaration, if they passed something, an amendment that should be recorded, and I also rely on the management company that I'm paying my clients money to get a complete 22.1 disclosure. And what if it isn't complete? And what if I pass it on to the buyer's attorney saying, "This is what I got, this is what I'm giving to you, and there's something missing"? Who's on the line for that? And you can say it's a lack of due diligence, maybe not, but certainly the question is that how can you be assured as the seller's attorney that what you got from the management company is complete, so that when you pass it on to the buyer doesn't come back to you in a couple of years or a few months or whatever and have a beef. My second anecdote, I'm on the broker lawyer committee of Main Street Organization, and I got to one of our committee meetings early, and a couple of the broker members were talking about the fact that another broker had received a complaint through Main Street Organization because at the time she bought her condo, she did not own a dog, but she had not been told that the association doesn't allow dogs in the association. And now she had gone to a rescue pound, and she now has a dog, and they told her, "You can't, because we've never allowed pets in the association." So she came back to her broker. Now, I don't know if she had a lawyer or if the lawyer was involved, but she came back to the broker and said, "You should have told me at the time that even though I didn't have a dog, that I couldn't get a dog if I wanted a dog." And here again, you have to look at it from their standpoint and say, okay, what do I have to know about you and your personal life and your future as far as what you're going to want out of the association so that I can tell you, you can't do that. My third quick anecdote is the fact that I had a client who was told by the association that they couldn't rent their unit because of the rental restrictions in the association. So I said, well, have them send me an excerpt or the full declaration, or if it was passed by the board, send them to me so I can figure out whether or not what the parameters are for renting units. And based on my reading of the anti-rental provisions, anywhere from no units could be ever rented to all of the units could be rented, and it was fact specific as to at what point in time, because it included how many units how many units the developer still owned. So if the developer still owned more than half of the units, then none of the units could be rented. But if the developer owned none of the units and other factors came into play, then all of the units could be rented. So these are things that when people buy condominiums, they may have questions about, but these might not be questions until for years down the road, but they need to know what's in their association documents. So now let's switch gears a little bit. Now we're going to talk a little bit on the buyer side. And I was going to do a quick overview, as I generally do, about the documents that are that need to be disclosed under 22.1, but we've done these so many times and they're all listed. I won't go through them item by item, but obviously a big one is number 3, and that's the anticipated expenditures that the association reasonably expects to incur in the coming years. But often buyers' attorneys request additional documentation besides what's in the 22.1 disclosures, which is bona fide because they have a right to determine whether or not, in their view, the association is suitable for their uses. But when they request things like the financial statements on the association, whether or not there are adequate reserves, whether there's a useful life schedule on the material assets, and the budget for the past 2 years and the projected budget for the coming year, how many attorneys in this room feel that they have the adequate financial statement analysis to determine that if they went through those budgets and went through those useful life schedules, that they could determine that the buyer's investment in this association is still as good as their buyer hopes it will be? And I don't either. I took sophomore year accounting 101, and I'm proud to say I passed. But outside of that, I don't feel that I have the professional acumen, nor should I probably rely on any understanding that I have in my career as far as going through financial statements of an association to determine whether or not the association is in good shape, whether it can afford its anticipated expenditures, whether it's adequately reserved. And in fact, based on my little education and financial statement analysis, I've taken a look at some associations in which it's clear that they have no reserves. They're running on empty. It's a small self-managed association. They've set aside nothing for major repairs. And so basically whoever buys into this association, it's going to be somewhat of a crapshoot as far as when the elevators stop running, when the roof needs repair, when the tuck pointing needs to be done. Now, most of my practice involves short sales, which are sold as is. I argue that the financial condition of the association and its future ability to maintain the property is included in as is. The financial statement of the association is as is. It's up to you to decide, once you review them, if you either want to continue with the contract or if you want to use the financial condition of the association to bail on the contract. But that's going to be your decision based on what the seller has provided to you. The $64,000 question is does the buyer anticipate that the buyer's legal counsel will review all of the condominium documents, including budgets, useful life schedules, to determine that the purchase of the condominium is still a wise financial investment? I would suggest to you that if you're going to charge the client for reviewing the condominium documents page by page, and as I said, quite often they exceed 100 pages once you have everything in the entire package, that you first make sure that you have the ability to opine on all of the documents, and if you don't, which documents are you not going to opine to? Secondly, you sort of have to anticipate one thing you have to anticipate is what does the buyer expect? What are their plans for the unit? Now, some people buy condominiums when they downsize. When they're empty nesters, they decide they don't want to keep mowing the lawn. They'll buy a condominium because they'd rather pay a few $100s a month to the association than having to maintain it, which is a very wise investment. However, how often do we discuss with our middle-aged to elderly clients who buy condominiums that there might not be a hardship restriction on the ability to rent the unit out in the event that they have to go into assisted living or a nursing home, or in the event that they die and it's a down market and their heirs are having a hard time selling the unit for a good marketable price or at least what's owed against the unit. So a lot of these are considerations that I think the far better tact for a buyer's attorney is to include in their engagement agreements the fact that I'm not charging you to review any of the condominium documents, and therefore I'm carving this out of my engagement letter that reviewing the condominium documents is either up to you or someone else that you hire, and maybe you should hire an accountant who can go through the financial statements of the association, because not only do I not have the qualifications to give you a complete analysis of the financials, but also I would have to charge you to read the declaration line by line and then anticipate if there's anything in the declaration that you would have a problem with if you had read it yourself. Now, you can also flip this over to them and simply say that since I'm not doing it unless I charge you, and you're not going to like what I charge you because it's going to take me a minimum of several hours, and that's not included in the piddling fee that I get for handling the transaction for you otherwise. And you should turn it over to them for them to read especially the declaration and the bylaws, to make sure that depending on their present needs or what they anticipate their future needs to be, that the condominium is going to be suitable from that standpoint. You can do this by limiting, obviously, the scope of your representation. You can do that in your engagement agreement. But also, I've heard, as in the one instance I mentioned with Main Street Organization, that sometimes the brokers will know what the buyer intends to use the unit for, especially if they intend to buy as an investment and at some point in time rent out the unit. Sometimes the real estate broker will know things that you probably don't know about, because some of these real estate brokers have done previous transactions with the client. They may have helped them buy their big house with the lawn, and now they're helping them sell the big house with the lawn and buy the pretty condo in Buffalo Grove. So sometimes the buyer's agent will know a bit more, and sometimes a lot more, about what the buyer's anticipated needs are than you may, because you've got a large volume of cases. You can't spend as many hours representing these clients as you may need to, and you certainly can't charge them for the additional work that you do. So here again, I'm not really providing you with any answers. I wish I could. I think you're getting, as well as I am, a pretty good handle on the scope of the problem with very few solutions. But especially in cases that we see, as in the Mokalecki case, and we're seeing more cases. Joe and Steve and Eric had mentioned this morning about other association cases that are coming up. So the need to find deep pockets as far as the management company is concerned, and as far as the seller's attorney is concerned, that desperate times lead to desperate measures, and desperate measures look for deep pockets. So I would caution you that think about your relationship regarding your clients when you're handling condominium transactions, and act prudently as far as your engagement letters are concerned. Do I have any questions or?
John O'Brien has many hats. One of them is he's on the MCLE board, so he's going to make sure that we have our interactive discussion and question and answer period, and we fulfill our MCLE requirements. We've got several minutes left, so this is the time to ask questions.
Okay, yes. Hold on just a second. We have a mic for you.
Thank you. So as to the 22.1, a buyer's only recourse is against the seller and not against the management association or the homeowners association?
Based on Mokalecki, that's the case, is that the 22.1 disclosures are prepared. Actually, they're prepared by the association, although the management company is the one that actually prepares the 22.1 disclosures on behalf of the association to be provided to the seller. Because that, under the contract, it's the seller's obligation to provide those to the buyer. And the Mokalecki case made it clear that the 22.1 disclosures are something that's prepared for by the association or the management company for the seller to provide to the buyer. So in the Mokalecki case, clearly the property management company was not responsible. It's my understanding from the opinion that as soon as the management company was dismissed from the case because it wasn't their responsibility, the association, I believe, settled the case or offered to settle. So they tried to get out of the case also. But ultimately, the court felt that it was the seller's responsibility to provide the 22.1 disclosures to the buyer.
So if the buyer sues the seller, can the seller turn around and counterclaim against the association management company for providing inadequate or defective documents? Are they liable to the seller for providing proper paperwork?
Well, that's a good question, because the issue would be is as to whether or not the seller, as a unit owner in the association, has privity of contract with the management company. And if under the management agreement that's in place, it's the management company's responsibility to provide adequate 22.1 disclosures, then that would be really what the key issue is does the seller as a unit owner have privity of contract with the management company so that they could sue the management company. The first defense for the management company is that we provided to the seller everything that we had from the association, so if it's incomplete, if it's inadequate, then it's the fault of the association who failed to provide us with adequate documentation for that. So,
Use the microphone, please.
the question is, one or both of them then could sue the seller. Yes. Well, and here again it depends, because it's the seller's responsibility to provide the 22.1 disclosures. So if the seller can say the 22.1 disclosures that were given to me by the association is exactly what I gave to the buyer or the buyer's counsel, then I assume that the seller would be off the hook if they provided the 22.1 disclosures. In the Mukaleki case, the twist was that they felt that the seller knew something that, whether the management company knew it or not, that the seller should have disclosed either in addition to or included in the 22.1 disclosures, because nothing in 22.1 puts it onto the management company or even onto the association to provide this information. They put it onto the seller to provide it. Now, if I'm representing a seller and he says, you know what, don't spend the $500 on the management company, just get the paid assessment letter, because I have all of the other stuff and I'll give it to you. I'm very good. The question is can you rely on whether or not the seller is going to provide everything that the association had? In other words, is there something missing in the seller's files that if you rely on what the seller provides directly to the buyer, the question is, did that comply with 22.1? So 22.1 does not require the association or the management company to provide it to the buyer. It's the seller's responsibility. But even if the seller says, I have all of that information, I'll give it to you, just order the paid assessment letter before the closing, I don't think that still fills the bill if there's something missing from the 22.1 disclosures that the seller wasn't aware of. And the question here again is what does the seller's attorney do from a due diligence standpoint to make sure that what they got from whoever they got it from, directly from the association, if the association is self-managed, or if they got it from the management company, or if they got it directly from the seller, to make sure that what's being provided is exactly what complies with 22.1, that it's a full disclosure and that there's nothing missing.
Has there been any movement in the legislature to expand 22.1 to include things such as minutes, reserve study, some additional documentation that might be useful to buyers?
I haven't heard of any movement. I don't know. I haven't seen it come up in the legislative updates as far as what's being anticipated. I know there are a number of measures before the General Assembly that regard changes in the management of associations and, in fact, how the association boards of directors act, but I've seen nothing yet as far as trying to expand the scope of what the 22.1 disclosures entail. I think they leave it up to the buyer's attorneys to decide, given the scenario, what additional factors they would, that they would require. Some associations have very few capital assets that would have to be replaced at some point in time, such as boilers. The roof shouldn't have to be replaced as long as it's maintained. A lot of associations don't have elevators, even though it's on multiple stories. So a useful life schedule with some associations is probably going to be less important than it would be in other associations in which it's a high rise and that there are going to have to be major capital investments made, and that they'll have to rely on the useful life schedule. And so that would be one thing that, on a fact-specific basis, you might require as the buyer's attorney.
Dennis, are you aware of any litigation pending against companies like HomeWise and Condo Certs who seem to be gouging, the homeowners, the attorneys, charging these rush fees? It seems like it's just getting out of hand now, especially when you have two associations. I had one where you paid $1,000 for condominium documents.
Right. I've seen no litigation. There is a discussion as far as what the association. Joe, do you have the update?
Joe
on
has some
that?
input on this. We had a real estate law section council meeting, and we are forming, a group to look into this. And one of the things that Joe will
Illinois
tell you
State
about-
Bar's Real Estate Section Council is trying to take up the issue and determine what exactly to do about it. Is a very difficult fix, but notice ought to be provided to the unit owners of what these fees are and whether there's a fee schedule. We also would like to propose that the Board of Managers approve such charges in their management agreement, and I don't know that that's being done. It almost can't be done unless they're doing it without examining it. But we've got a lot of very, very disappointed sellers who have to pay exorbitant fees. It gets to the point where if I get a condominium sale, I tell somebody, it's going to take you 60 days to close the sale, pay all your fees through that anticipated closing date and then some, and then we'll order all the documents now so we don't run into a so-called late fee. But until such time as we can get either education or a legislative fix, I don't know how, it's just going to keep on growing.
Which may in fact be one of the additional disclosures that a buyer would ask for, is to know what the fee schedule is in advance, so that when the buyer becomes a seller, they're not really surprised as far as what the fee schedule is that the association is charging. But I bet there are many associations that aren't even aware of how much the management company charges for the documents, especially including their expedite fees and everything else.
And let me just say, not to risk stating the obvious, but the dynamic that we run into all the time is that the seller who's getting gouged on the way out is just closing that chapter of their lives. They're not going to come back to the next unit owners meeting and complain about how high the fees were, So we have to have some kind of checks and balances on this and some governors. And one of the things that Joe is working on, because he was spearheading this initiative to try to have some way to bring this under control. Joel Chupak is working with a representative to try to develop some legislation. We would, I think, like to see at least a minimum annual disclosure of what the current fees are for the management company. And I'd like to see also an additional requirement that if that fee schedule changes, for example, if they start adding extra fees for producing minutes, because everybody's asking for 2 years of minutes now, that increased fee would be disclosed to the unit owners at some general notice, like within 30 days of the time that fee increase takes place, so that a seller getting ready to sell has some clue how badly they're going to get hit.
And that's one of the big issues, is the fact that the associations, because of the fact that the fee charged by the management company isn't something that goes through the association. And as Ralph mentioned, once the seller sells the unit, they're not going to complain about how much the association documentation cost or the other fees that have been charged by the management company. Because the association isn't really either aware of it or really doesn't care, because they're not the one footing the bill. They may have a ticked off former owner, but because it's a former owner, they could probably care relatively less. So that's one of the major considerations. But one of the things that I wanted to talk about was the excerpt from the Mokalecki case. The real takeaway from this case is this: what is a purchaser's attorney to do if they cannot rely on the 22.1, since according to Mokalecki, it is only prepared for the seller? In the association, I'm sorry, in the opinion, The court pointed out in his discovery deposition, defendant expressly denied ever having received the letter October 27, 1999, and denied knowledge of the upcoming window replacement program. This was the letter that had been sent out by the association along with the budget to show what expenditures were that they anticipated. The letter said that the board is also researching a window replacement program to begin in early 2000. Now, this is back in 1999. In early 2000, the scope of this work will exceed capital reserve funds currently available. Therefore, we are also investigating the ability of the association to borrow funds to make these necessary improvements. The securing of a loan would result in an increase to assessments. Therefore, after the capital program is finalized, the 2000 operating budget will be redrafted to include a loan payout. So back in 1999, when the sale was anticipated, the association already knew that there was a possibility that there would be a window replacement program, and that would significantly increase the amount that the association would have to charge for the assessments. The plaintiff argued that the material facts in question remain in dispute as to whether defendant violated 22.1 of the Condominium Act. And they looked specifically at number 3, which is a statement of any capital expenditures anticipated in the unit's owners association within the current or succeeding 2 fiscal years. And they relied on a plain reading of 22.1 to decide that that included what the association had already disclosed in the letter. In the present case, information pertinent to the financial status of the association was similarly withheld from plaintiff, which may have affected her decision to purchase defendant's unit and raises disputed material facts. These are questions as to whether the defendant provided to plaintiff all of the vital financial information necessary to make an informed decision. As the seller of the unit, defendant was the only individual in the position to request information from the board, and he must make a good faith effort to do so in order to comply with the statute. And therefore, on that basis, they found that it was the seller's responsibility because they were the seller was in the best position to ask the association for the information required, and they didn't pass that responsibility on to the management company or, in fact, actually onto the association, regardless of whether or not the information that was provided was incomplete. Okay.
5 more minutes.
5 more. We have a few more minutes if there are any other questions.
Everybody do an engagement agreement with their clients?
Oh, I'm sorry. The site for the case is 825 Northeast 2nd, 266, 355 ILAP 3rd, 1006, and 292 Illinois Decisions 10. And it came out of the 1st District in 2004. Just 2 real quick updates from what we had talked about before is that after we had talked about whether or not the grace period notice statute had expired, we've checked on the .gov website, and based on the statute, as of yet there is no extension on that statute, and the expiration date was July 1st. Of this year. So as far as the requirement for grace period notices, it appears at least from this point that that statute has not been extended, and therefore that defense of not providing a grace period notice after July 1st of this year will probably not be effective. The giving of the grace period notice has been determined to be a condition precedent prior to the filing of the foreclosure complaint, and therefore, if the statute is not extended, then that foreclosure defense will wane very quickly. The other point that I wanted to make, Steve and Joe talked a little bit about the CELAC decision on tenancy by the entirety. I'm sort of embarrassed to say that was my case that got declined by the appellate court. We're in the process of filing a motion for rehearing on the basis that, and I'm sure that Joe and Steve will both be amused at my comments, but it's well established in Illinois that a mortgage is only incidental to a underlying debt, and there are a number of cases, especially cases where the note was bifurcated from the mortgage, where the note had been assigned to somebody else than the party that entered that had the mortgage, and the person who had the mortgage could not enforce the mortgage because of the fact that they weren't the holder of the debt. And these cases go back actually before we can report decisions. That would be 1935. Some of these go back to the 1920s. And there is no exception in tenancy by the entirety for consensual liens. And in fact, actually in the CELAC opinion, the appellate court pointed out that the mortgage that was signed by the non-debtor spouse was a consensual lien, and they therefore felt that a consensual lien created joint debt. But they also say that they also acknowledge the fact that a mortgage does not create debt, and therefore if a mortgage is a consensual lien, then a consensual lien does not create debt, just like a mortgage doesn't create debt. So that case, along with a couple of other issues that we raised on appeal, we're asking the appellate court to be reheard, and depending on that, we may consider whether or not we take further steps. But that's an update on the CELAC matter. Okay, if there are no further questions, I'll turn it back over to Ralph. Thank you very much.